Good morning, good afternoon, good evening. My name is Alidad Vakili. I'm an attorney with Foley and Lardner. I'm in our corporate group, and I practice primarily, my practice is focused on representing startups, emerging growth companies, investors. With regard to the startup space, it's everything from garage to global. So from very, very beginning onset all the way through exit. And I'll give a little bit more detail about that in a moment. But let me go ahead and see if we can get started here. So just a very quick overview, give you a preview of what we're going to be talking about. I'll do a quick introduction. We'll go through talking about how to document the deal, capitalization issues that come up, good corporate hygiene, and then preparing for your first deal and diligence. And I chose those topics because those are areas where I have seen over many years of practicing, where there's a lot of missteps and where there's a lot of potential traps, or where founders, entrepreneurs, executives, et cetera, can get a little tripped up over. So I'll walk through some examples, and then if you have any other particular comments or thoughts or questions you have, then certainly raise those and we'll try to address those as well. So let's go ahead and get going here. Okay, so a little bit about my background. As I mentioned, I'm Alidad Vakili. I'm with Foley and Lardner. Been practicing 25 plus years, based in San Francisco, and a lot of my work is focused on, a variety of different industries and sectors. It's all corporate focused, and it's a lot with, as I mentioned, sort of garage to global. So very early stages of a company where it's the stereotypical, a couple folks in a garage with an idea and don't know what to do, helping them organize, choose the right entity, get formed, create a structure for them so that they can go out and raise financing and carry that all the way through their journey to some sort of exit, whether it's, a M&A transaction where the company is sold, or if they're going to go public, helping them with all of that. It's really enjoyable to work with incredibly smart, innovative, thinking outside the box entrepreneurs and founders who have come up with some really cool stuff. I mean, over the years, I've seen and been involved with some pretty cool companies that have developed some amazing innovative technology to solve some either urgent issues or pressing problems. And some of them are simple, and you wonder, well, why didn't I think of that? When some of them are so complex that you need a PhD to understand. But it's been really rewarding to get involved and play a small part of that, the success that a lot of these startups will have as they go along their journey. Okay, so let's go on now to, I'm going to go ahead and do a poll. I want to get a sense of where people are from and sort of what their backgrounds are. So let me ask 3 short questions. Just take a few seconds if you don't mind. It helps me understand the audience so that I can better sort of adjust some of the topics and what we talk about. Okay, so you should be seeing some questions on your screen. And just take a moment and answer the one that best fits you, or for example, the first one is where you're located. Give you a few seconds for that. And then let me move on to the next one. What is your role or title? So again, this helps me understand, are you an entrepreneur, founder, executive, investor, advisor? And the last question is, what industry you're in? You could be some other industry, so just put other if this doesn't fit the industry you're in. Okay, so I'll give it a few more seconds, and then we'll go ahead and see the results. As I'm seeing people pop into the webinar, I'm seeing a lot from the US, Bay Area, so my hometown, and a lot from actually overseas as well, which is kind of cool. So it's a pretty, looks like it's a pretty diverse group today. Okay, so let's go ahead and check out. Okay, oops. Okay, all right, so let's go and see the results here. Okay, so it looks like about 67% are from the US. We've got about 4% from Canada, 11% from Asia, 7% from the EU, and 11% from other areas. So the majority of the folks are from the US. Welcome all of you. And I know some of you are it's your evening or maybe late evening. So really appreciate your taking the time to join this presentation. Looks like about 43% are entrepreneurs, 39% founders, 14% executives, and we have 4% that are advisors. So that's a great makeup. And then on the last question, what industry you're in? Healthcare, life sciences, 21%, technology, 41%, energy, 7%, and then the remaining 31% is just others. So great. Well, anyway, wonderful to have you attend. Let's go ahead and get started and start talking about some interesting stuff and hopefully give you some tips for avoiding some of the big startup mistakes that I've seen over the years. Okay. I always like to throw a quote on there because quotes are great, and in a very short sentence, they can capture so much. So, this is one by Oprah Winfrey: "Failure is another stepping stone to greatness." You see this in the startup world a lot, and I'm sure all of you, if you've been through this before, know that, I don't see failure as a negative. It's a positive because, you learn so much by the failures. I like to call them challenges, and it just makes you better, stronger, more resilient. Okay. So the first topic is documenting the deal. I mean, I see this all the time because, for whatever reason, I know folks like to either do things on their own. They don't seek good counsel or advice. They don't think they or don't have the budget or don't think they have the budget for it. So they inevitably try to negotiate and document, maybe an early deal. And sometimes it can go well, but I've seen some war stories, and I'll share one with you. But essentially, it's dangerous if you don't know what you're doing. If you've been around the block and you've had a bunch of successful companies and you've gone through the process, it's one thing. But especially if you're new, if this is your first venture or maybe it's your second venture, and you don't have a law background or you haven't been through enough of these to understand some of the intricacies and where issues can come up, it's just an invitation for disaster, not getting good advice. So I think, the one example that comes to mind is what I call a napkin deal. And essentially it was a technology creator created a fantastic technology for the photography video industry, really, really great technology, and needed someone to help manufacture the product. So he reached out to a friend of his who had a manufacturing facility. They sat down, and it's called a napkin deal because on, basically a short one-page piece of paper, they scribbled out and signed an agreement. And the agreement essentially provided for the co-founder, the friend that he brought into the company, to get 50% of the company for the promise of providing manufacturing services. So that person, she was supposed to provide manufacturing services, make sure that the product is manufactured, produced, so that then the company could sell it. Unfortunately, after 4, 5, 6 months and struggling, the original founder realized that the friend she couldn't deliver. She didn't have the wherewithal, didn't have the experience. The products were coming back defective. They weren't operating. There were tremendous delays. And then the co-founder basically said, well, I can't keep spending my own money on this, so I need the company to pay for the manufacturing costs. And this did not sit well with the original founder because his whole point was, I gave you 50% of the company so that you would come in and take care of that piece of it. So now you want 50%, plus you want me to cover all those expenses. So as you can imagine, the relationship soured and ultimately ended up not going anywhere. So what the resolution was that they came to was the founder, who really wanted to move forward with the company, had to source manufacturing from someone else. So he basically bought out the co-founder. It was very expensive. Unfortunately, I wasn't involved when they first did the napkin deal. I wish I had been. They came to me after that deal had already been signed and the relationship wasn't working. So after reading the very short one-page agreement, I had a long talk with the founder, and I said, look, he's got 50%, and the only way you can get out of this situation is, buy him out, because they didn't want to work with them. Relationship wasn't going to improve. So it was an expensive lesson. So the takeaways is really do your diligence. I do a lot of work forming companies, talking to founders, talking to co-founders, and I always tell them, when you're getting into a business together, it's really like getting married or dating. You really have to know the person that you are going to be tying the knot with, or in the business world, starting a company with, because it is really like a marriage. It's going to be a relationship where everything's going to be tested. emotions, work ethic, ethics, responsibilities, leadership, management style, all of that and more will be tested. And so not knowing how someone is on a number of those different traits and factors is asking for potential problems, because you may sign a deal, bring someone in as a co-founder, and realize they don't have the background they said they did. They may be really good at one piece, but they're horrible at a whole bunch of other areas that are really important to be a founder. And so now you're dealing with a potential problem of, what do I do? I've got to fill these gaps. The other thing I oftentimes advise people is to troubleshoot. So ask the what if questions. We're oftentimes paid as to be the cynic or the skeptic in the room, because we're the ones as lawyers asking all the what if. Well, what if this happens? What if that happens? What if it doesn't go this way? What if the business can't get the next financing? Those are all the what if questions that are good to ask, because it forces you to think about what's going to happen if there's a bad case scenario or worst case scenario. How are you going to react? How are you going to plan for it? That oftentimes is a very good way to troubleshoot whether or not someone might be a good partner. And I'm talking about this particular example where there was a founder that brought in a co-founder, but it applies to any kind of relationship. So if let's say you're going to do a joint venture. So you start your company, got great technology, you realize there's some other aspect of the technology that another company has that might be a great way to partner up with them and do a joint venture, then that's just like bringing in a co-founder. You're going to have now a joint venture partner, if you will. And so a lot of the same types of issues are going to come into play. And it's really important, especially whether it's a founder scenario or a joint venture or some other arrangement, to get good legal advice. Talk to your lawyer or get a lawyer so that they can do the troubleshooting with you. They can help you with the diligence. They can help you document the deal properly, which is the next bullet point item. Really critical, because, and everyone's heard this, but the devil is really in the details. And until you go through the agreement with a very careful eye and experienced eye to see where there might be problems, or putting into it provisions and terms that will be helpful, that will be protective, you might be missing some things that will be critical. The other thing to realize, and over the years this is borne out to be true, resolving a problem is going to be so much more expensive than dealing with it in the first place up front and working on getting it done in a way that will prevent some of those problems. Okay, so I know we had a whole bunch of people that joined, so apologies. I know it's 9:15. We got started so we can kind of run through the material and leave a lot for the Q&A session. So if you missed anything, happy to have an online conversation. Email me. Happy to try to make sure we can get some of that stuff that we covered before you joined to you as well. So what does documented deal mean? I mean, it's sort of self-explanatory, but some key things to consider, and this will vary from agreement to agreement, but sort of the general high list items that I think of is, and this necessarily isn't in the agreement, but it's an important part of the process, is take some time and sort of outline the relationship. So whether it's bringing in a co-founder, whether it's bringing in an employee, whether it's bringing in a joint venture partner, or using a particular vendor or consultant, think about the relationship and how it's going to work between your company and the other party, and what do they bring to the table. Where are their strengths? Where are their weaknesses? I know this seems it may seem a little bit uncomfortable, or it may seem a little non-intuitive, but actually going through and making an outline or making a list will help you focus on those things, because it really is important to know, as I mentioned earlier, who you're getting into the relationship with. Understanding who the parties are going to be. Sometimes there's multiple parties. The key terms of I'll call it a relationship, because essentially when you enter into an agreement, you're trying to put confines around a relationship that's going to be on paper. So you're trying to basically draft for encompassing what that relationship is going to be like. And as you can imagine, that thinking about that conceptually is a bit of a challenge. So it can be a little daunting sometimes. But key terms: ownership, depending on if there's an ownership piece, timetable, obligation of the parties, who's doing what, when are they supposed to be doing it. Confidentiality is really important. Limitation of liability, indemnification. So just a few moments on those items, and I'll always come back to those in the Q&A or reach out to me separately. But Confidentiality is really important. So whether it's a co-founder, whether it's an employee, consultant, JV partner, et cetera, even customers, if you've got something, if you've got some secret sauce you don't want to be out there in the public, then make sure you've got confidentiality protection. So that should be something that is an automatic, do I need this? Should I have this? The answer will probably be yes in many of your agreements. Limitation of liability or indemnification. So this is something that, I think of oftentimes if you've got an agreement with a vendor, supplier, a manufacturer, it could be a joint venture agreement, a number of other types of agreements. But one of the areas to focus in on is, where are the potential liabilities? Where could there be a problem? If worst case scenarios or bad case scenarios came up, what is my exposure? What is my meaning the company's exposure? And the limitation of liability and indemnification kind of go hand in hand. So, is there a way to limit liability? And you see this oftentimes with SaaS agreements or commercial agreements where one party is providing services or products to another. If something goes wrong, if you're the supplier, so you're providing services and something goes wrong, and what goes wrong is a huge liability that's many, many, many times more than the amount of payment that the supplier received. How do you manage that process? And is there sort of market terms that you can look at as guidance for that? And there are, and it depends on the type of agreement, the industry, the issue. There's a lot of different factors, but it's important to be thinking about that so you can plan for it effectively. And an indemnification agreement is another way to provide some protection. So if something happens, do you have a right to go back to that party? Typical example is a third-party claim. So two parties get into an agreement, something happens, a third party comes and sues because they've been injured. Who covers that expense? These are just a few. There's a lot of other things that should be thought about and considered, but these are some of the top level items that I just wanted to mention. And the other thing I didn't mention at the very beginning, but let me take a minute to talk about it really quickly, is this is an educational presentation, so nothing I say here should be thought of as legal advice for your specific or particular circumstance. It really is just educational. It's meant to be sort of high level to paint the picture of what's important. And then obviously, if you need help, reach out to a lawyer and have a specific discussion on your particular issues. Okay, so let's now talk about another topic that comes up oftentimes that I see where there's mistakes made is capitalization and not managing the cap table of the company effectively or appropriately. So the cap table is, hopefully all of you are familiar with this, but if you're not, the cap table is used to be in the old days and oftentimes still is a spreadsheet where you list who the owners of the company are, what their ownership, what the shares are that they own in the company, and their ownership percentage of the company. And it's really important as a founder or an entrepreneur to, and as an investor as well, but really important to focus on that, because you want to keep track of your cap table as you grow and scale. If you're going through fundraising, financing, and you're selling shares in the company, then you're going to get diluted. Your ownership is going to go down because the more shares that are out there, the less ownership percentage you will have. And so how to manage that, how to understand it, how to work through those issues that come up is going to be really important. So an example of where things went wrong, a war story, if you will, is there was a company that had formed with a minimal number of authorized shares. So when you first form your corporation, you file articles of incorporation. In Delaware, it's called certificate of incorporation, and you authorize a number of shares. And those are the number of shares that you're going to use to issue to founders, and you may issue them to other folks, employees, et cetera. But you need to have enough shares to be able to issue them. So think of it as a checking account. You open a checking account and put $1,000 in your account. If you've got expenses, you can't spend more than $1,000 because that's all you have. So shares work the very same concept. If you have 1,000 shares, but then you go out and you say, well, I want to bring in John and I want to bring in Jane and Laura and I want to give them shares, but I've already issued 750 shares to myself, but I want to issue them more. You're a little stuck because you only have 1,000 that you authorize. So you've got 250 to play with. If you want to have more than that, you've got to amend your charter and increase that number, which you can do, and it's not a problem, but you just need to be thinking about that. So the example of the war story here was basically the company set up minimal authorized shares. They hired a whole bunch of people, had a whole bunch of consultants. They then did a forward stock split, which essentially means you take one share and you multiply it by a factor of, whatever, 10, 100. I think they multiplied it by a factor of 1,000. So you still have the same ownership in the company. You still have it's the same value, but essentially now you've got more shares because you've taken one share and cut it up into 1,000 pieces, if you will. Sometimes it's effective because then the per share price comes down. So it's more affordable for employees who are getting options, things of that nature. So they did a forward split. And I think it was 1,000 to 1, if I recall, but they didn't do the documentation properly. They didn't have an attorney that handle it. They didn't calculate the share properly. But the most important critical piece was they didn't amend the certificate of incorporation, because the only way you can do a stock split is you've got to amend the charter to provide for that split. If it's not in the charter, it never happened. Well, they never filed that. They drafted it, but they never filed it with the Secretary of State. So effectively, the split never occurred. They didn't realize that. They went on and started issuing a whole bunch of shares, but they weren't issuing them under the original authorized number of, let's say it was a million or something. They started issuing, in the millions. So they would issue someone 300,000, 500,000, a million. So they went past the number of authorized shares they had, and it created a major problem because we had to go back and try to fix it. And it created a big mess because we had to talk to the shareholders, advise them of what had happened, and try to get them to sign off on cleaning up the cap table. So key takeaways: capitalization structure is really critical. Set it up right. When you first create your company, or if you've already created your company, take the time to go through to make sure it's all updated and accurate. And get legal help. There are also some really good legal tech solutions out there. So there are cap table management programs you can use. One of the more popular ones we see oftentimes is Carta, and they have a great program because you sign up. It's a subscription-based program, but once you upload everything, you do the onboarding, then essentially you've got everything in the cloud. You can go and make changes. You can issue stock certificates, issue grants, all electronically. It makes the whole management piece a lot simpler. There's a lot of other features it has too, but they're one of a number of companies. There's a bunch of others as well. Again, this is a recurring theme. The resolution to fix something that's not done right the first time is going to be significantly more expensive. Okay, so let's talk now about, Okay. The other aspect that's important in capitalization, I'm going to touch on this quickly too, is how do you allocate equity amongst founders, with employees, consultants? This comes up all the time because when you're a startup and if you've got limited funds, you're not going to be able to pay, the salaries that would be competitive. So you have to attract people by saying, look, come work for me and I'll give you some equity in the company. That's one piece of it. The other piece of it is if it's two people in a garage coming up with an idea, how do you decide who gets what? It's two people, two founders. Should they split it equally? Should one have more? Should one have less? I take you back to the beginning part of the conversation where it's important to understand who's contributing what do they bring to the table, because that will be a key factor in determining how to allocate equity, especially amongst founders. If someone's got the technology and they're also putting in the money, but they want someone else because they've got a good finance background or they've got a good network, then does it make sense to do the split 50-50? Because one founder is putting in the tech and the money initially, and the other founder is just contributing a Rolodex of some valuable contacts. Those might not be on par, might not justify a 50-50 split. It might be some other kind of a split. So something certainly to be thinking about. Okay, so striking the right balance when allocating equity. Think backwards when planning. So where do you want to end up ultimately? And then start walking backwards to try to get there. So for example, there's oftentimes two main features when you're looking at allocating equity in a company. In general, running a company is there's control and there's economics. And as a founder, obviously you want to have the majority of both, because that gives you more skin in the game, more stake in the game. And when there is an exit, if you've got more of the economic side, then obviously you'll benefit more. But you also want to have as much control, because if it's your idea, your brainchild, your technology that you developed, you want to be able to control it to the point where you can grow and scale the company, at least until the point where if you've sort of hit your ceiling of experience, and now the company's so much larger and you're not as familiar with growing a company to the next stage, you might need to bring someone else in. But at least having as much control as you can for as long as you can is something that's good for founders to be thinking about. You need to plan for dilution. It's going to happen. So as soon as you start issuing shares, granting options, there's going to be a dilutive effect on the founders. And that's why I say get a cap table, get it done properly, and then just make sure you're managing properly so you can see what's going to happen. If I bring in 10 employees and I allocate X% of stock to them or X number of options, what's going to happen to my ownership stake? Incentivizing your team, that's, I think everyone kind of understands that, is, give them equity, make sure it's, it's fair, but it's also you're keeping your eye on the dilutive effect that you're going to have if you're the founder. I've seen oftentimes a mistake comes in where the founders want to bring someone in, they're excited, this person's really great, they're going to help grow the company, and so they just offer them, a huge percentage of the company, which probably is not market, probably doesn't justify what the person's bringing to the table. And if that person doesn't work out, what do you do? So you give 10% to someone, they come aboard, you give them stock, they show up, and in 3 months you realize they don't know what the hell they're doing. They had all these contacts, they can't sell, they don't understand the technology, and now you're stuck. So good planning with good legal advice will help avoid or at least mitigate some of those problems, because in the documentation, the next bullet point of proper documentation, you can have measures and protective provisions in there that allows for vesting so they don't get all the stock at once. Or if they do get it all at once, it's subject to vesting. So if they were to leave, or if you need to terminate the relationship, the company can buy the stock back that's not vested at the same price that they purchased it for. So it gives the company some additional tools if something goes wrong in that relationship. So think back to when I first started talking about how to govern the relationship. So the good documentation will have some of those tools in there to help you best manage that relationship, including if the relationship doesn't work out, what does the company do to protect itself? Okay, let me run through. Good corporate hygiene is another title you may hear, or a phrase you may hear. And essentially, it really just means good, proper documentation. And I know it sounds really simple, but as founders, and having worked with founders and entrepreneurs for many, many years, I know you get busy. There's all sorts of stresses, and some stresses will, rise to the top because it's, I need to get the technology developed. I need to get to the next stage. I need to get sales and revenues, or I need to get the next, financing done. I don't have time for this. I mean, yeah, it's important, but I'll deal with it later. So what oftentimes happens is the documents aren't signed, they're not dated, or important documents are just missing because either there wasn't good legal advice or no legal advice, or the founders didn't get to it, and now it's been 6 months and there's a problem. So an example, company starts up, they bring someone in to help with developing their technology. So they find a really good developer, and she comes in, she writes awesome code. Now they've got the source code that they need. It's going to be incredible for the business. Everyone's really excited. After about 5 or 6 months, the code's pretty much developed. The developer leaves. She says, you know what, I can't pull these hours anymore. I got an offer to go to a big company. They're going to pay me a ton of money. They're going to give me a bunch of options. Sorry, I love you guys, love working with you, but I've just got to go. So she ends up leaving. A few months later, company's starting on their financing, and the investor during diligence says, well, show us all the documents so that anyone that developed the technology assigned it over to the company. So they don't have any rights to the technology that was developed. This is a super critical point. Well, it turns out that the lady that came over to develop the source code never signed anything. They didn't have anything. They didn't get her to sign what is typically called an invention assignment agreement, or confidential information invention assignment agreement, or proprietary information invention assignment. So they're acronyms: CIIAA, PIIAA, and there's a bunch of other terms too. But essentially, it covers two important things. One is making sure that whatever that person does is provided, develops, obtains access to, is kept confidential. The other key point is that whatever that person develops belongs to the company. That's a really critical document, because without it, the person that developed, in this example, the source code, which has all the value for the company, never signed it. So technically she still owns it because she created it. And unless they can go back and buy that from her or get her to sign an assignment, they're stuck. And I've seen scenarios where that's happened and the company's been in a really bad space because they have no leverage. At this point, 3, 4, 5, 6 months go the wayside, and now you've got financing coming in. Now you go back to the developer and say, hey, we need you to sign this document. And they say, well, why should I sign it? Well, because when you came aboard, well, no, I didn't sign it. You never asked me to. And so I'm not really interested in signing anything right now. It can create a whole host of issues. So anyway, that's one key example. Other things are, not having proper shareholder actions or board actions. There are certain decisions that boards need to approve, certain decisions that shareholders need to approve, making sure you're managing that and staying on top of it. I don't want anyone to get overwhelmed if you haven't been through this process before. If you have, you're probably familiar with it. It's definitely manageable. But if you haven't, that's where you should lean on your attorneys and get some good advice. Talk to them, get even to the point of having some initial discussions about, hey, what are the sorts of things I should be thinking about that I need to get the board to approve, or I need to get the stockholders to approve. And that sounds like a simple concept, but believe me, I've seen plenty of examples where things that should have been approved by the board weren't, things that should have been approved by the shareholders weren't. And it's the same scenario, but now we got to go back and if we can try to get signatures in place, great. Sometimes shareholders leave, so you may not get them to sign. But most of those issues, or oftentimes many of those issues, can be fixed. Some of them, unfortunately, can't. Okay. Let's talk about other missteps if you're not being careful. So I want to be sensitive to our time. So we've got plenty of time. So some issues that come up if you're not watching carefully are what I refer to as sort of the sleeping devils, stock and option pricing. As a young company or a startup, it's really important to be aware of these issues and certainly talk to and get good guidance from your lawyers. But anytime, think of it this way, anytime you are issuing stock, it could be shares, it could be an option, it could be a warrant, it could be, and there's a whole bunch of other types of equity, convertible notes, et cetera. But if you're issuing shares or options specifically, you need to make sure they're priced properly. I mean, typically you want to price them at the fair market value. Now, options and shares are treated a little bit differently. If you're granting options to an employee or a consultant or someone else, then they should be issued at fair market value. And there's all sorts of tax consequences if they're not. If you're issuing shares to somebody, if it's a negotiated, financing, so you're raising money and there's a negotiated price that you agree on, that's fine. But if you're just issuing stock to some employees or some consultants, you also need to be careful that you're coming up with the proper price. It should be fair market value. There are tools for how to determine that. The best example I can give you, or the best suggestion I can give you, is go and get a valuation. And there are a lot of companies that do it. For example, some of the cap table management companies also will provide a 409A valuation. And the 409A refers to a section in the Internal Revenue Code. And that's where you look at as far as what the values of the shares or the options should be. And so as was mentioned, some of the capital management programs will do that. If you're using them and you have a subscription with them, they've got all the data there because you've uploaded it and you're using their service. So it's very easy for them to come in. They know the data, they know all the, the cap table information, to then go through and provide a valuation. Once you have the valuation, then you can go ahead and issue the stock or the options at the fair market value. I'm touching the very surface. It does get a lot more complicated. In some cases, you can vary from that fair market value within some slight degrees, but that's where you really need to talk to a lawyer that understands this area, because it gets very complicated. And the downside is, if you don't do it properly, there can be all sorts of tax consequences. So the war story here was a company that it was a startup, but had been around for a long time. And over the years, they had issued a whole bunch of options. But the problem was they didn't have good advice at the time, so they didn't issue them at the right price. They didn't issue them at the fair market value. So many years later, they now are looking to sell the company. On the diligence that the buyer is doing, they raise this issue saying, well, wait a minute, we're seeing a bunch of these prices here, but how did you determine what the fair market value was of the stock? And the founder of the company didn't have a good answer, didn't have a valuation report. So they kind of made their best guess. Well, it turns out that the best guess was a lot lower than what it should have been. So they essentially had issued options a lot less than the fair market value. And so the problem was, when typically in an M&A type exit, the people that are holding options, they can exercise them before the sale, but oftentimes what happens is they get cashed out. So it'll get exercised and then they'll get cashed out from the proceeds from the sale. But because they weren't priced properly, there was additional taxes that had to be paid. And they had a bunch of employees that had received these options that weren't priced properly. And the employees themselves weren't aware of this. The problem is the liability goes back to the employer, the company that granted these options. They should have known better, so they should have issued them at the fair market value. So the tax now, because the tax was on the employee, because the employee received, as an example, an option with an exercise price of $1, but let's say it should have been actually $2. So they didn't get the right price. They had to pay an additional $1 of taxes multiplied by the number of shares they had. It resulted in quite a bit. So the company had to then basically gross up the amount that the employees were going to get cashed out to cover that tax component. And it was a pretty big hit. It was in the millions. So may not seem like a big issue. If you catch it early on, it usually isn't that much and you can fix it. But if it waits and nobody pays attention to it, then you come to an exit and something like this comes up, it can be quite expensive to fix. Okay. Other areas that I see startups make some mistakes or missteps, if you will, are in not managing contracts properly. And think of it this way: as you start your journey, you're going to start with 1 or 2 agreements, but over the years, months, years, there's just going to be more and more agreements. So trying to implement a good strategy for managing your contracts. There's a bunch of programs out there, so there's some good legal tech that can help you. Contract management, and it can be as simple as how to save your documents in a data room and keep it updated with making sure that it's kept safe, all the way to having some more robust legal tech solutions where you can actually put the document into the legal management program and assign tasks, assign delegations, provide reminders, all sorts of stuff. So there's a wide variety of options out there. If you're working with a law firm, then oftentimes the lawyers will help keep track of your documents. So for example, on the clients that I have, oftentimes we have a pretty robust and intricate document management program. So we can track everything, every single document that client has. And so oftentimes that's a good way because it's in our system and we take a lot of care to make sure that it's protected and secure, but it's also easy to access. So there's lots of different solutions there, but just making sure you're managing it so you know where to go for contracts when you need to pull one, especially if you're doing the financing and now you have investors that are looking at the company, doing their diligence. They're going to want to know what devils are in the details of these agreements that I need to be aware of that might impact my investment. So they're going to be doing their diligence, and not being able to put your fingers on those documents and organize them is going to be one potential issue. But another issue is some of these agreements will have provisions that you just need to be thinking about as you're going through this journey, because as you go and raise another round, or you go and take out a loan, or you do a joint venture, or if there's a sale, you just need to know, is there anything in any of these many agreements now that the company signed that either requires approval or consent, or that there's some sort of termination provision. So as an example, if you have a particular key customer and when they negotiated the agreement, they had a provision that said, if there's a change in control, meaning if the company sold, then customer, can terminate the agreement and go somewhere else. And let's say 5-6 years down the road, the company's really successful now. That one key client became sort of the main client, anchor client for the company, and is driving 40-50% of the revenue coming to the company. So that's a huge amount of the revenue. So now you're coming to a potential exit, selling the company, and the buyer finds that agreement, finds a provision, and says, whoa, wait a minute here. If we close this deal and this big customer doesn't like us, they can terminate the agreement, and then suddenly 40% of the revenue that we were banking on, thinking that this target, your company is a really attractive acquisition, evaporates. Not a good scenario. There's ways to deal with that, but the moral of the story here is you got to know that stuff. You got to know what's in your agreement so that when issues come up, you and of course, consulting with your attorneys, understand how to deal with them, how to approach them, and also what you need to do. And it's never important until there's a deal in play and then questions are being asked. Okay, let's see. Oops. Okay, so another one that I think is important is, well, actually critically important, I touched on it a little bit earlier, is making sure you're protecting your IP, and refer to this as the crown jewels, but whatever the most valuable part of your company is, oftentimes it's the technology, oftentimes it's the IP. It's really important to understand how best to protect it. And there's a lot of different ways. I mean, there's the, sort of the, I need to file for patents because it's something that can be patented and I want that protection. I've gotten a name that's got tremendous goodwill and value, then I should be trademarking that name. There's other avenues, trade secrets, but those are all things that are important, and you should make sure that you go through that process and get the right attorneys to guide you there. But it's also important to understand when you're entering into agreements what provisions are going to touch on the IP. So this was an example of another war story where a company had hired a key consultant, similar to the other example I'd given you. They developed some software of the company that was really critical for the success of the business, but they never had an assignment agreement in place. And that person ended up leaving. They now had a scenario where they didn't own the technology that the person developed, and they were a little hamstrung. They couldn't move forward because no one was going to come in and invest in them if they couldn't tell the investor that, yes, we own or have proper rights to this IP that's so valuable that our business depends upon. And so it was really difficult to figure that piece out. They ended up basically going back to the person and negotiating to get that assignment. But as you can imagine, it cost them a pretty penny. So usually this stuff is part and parcel. When you sign an agreement with a consulting agreement, that language is built into this consulting agreement so that once that agreement is signed, you've got the IP assignment provisions that are going to be critical. And that's the best place to have it, because at that point, it doesn't cost anything extra. They're already doing it. That's the commitment. That's the service. They're providing these consulting services on the condition that whatever they develop for the company is going to be owned by the company. But getting them to sign it after the fact, if there's no compulsion or no requirement for them to, then unfortunately you're at their mercy of trying to negotiate a good deal. Okay. Let's talk about, and then I want to try to wrap up so we can leave some questions. Okay, so yeah, I was talking about the resolution of that, which costs a lot longer. The other thing really quickly to touch on is a lot of people will go and pull a document down from Google. They'll go, hey, I need a non-competition agreement, or I need a non-disclosure agreement. The state laws differ quite a bit on some of these areas. I'll give you one example. When it comes to non-compete agreements, there is a huge, difference between the different states. So, for example, in California, non-compete provisions, non-compete agreements are generally not enforceable, and they're against public policy. So, entering into one is just not going to be something you could enforce, even if you wanted to. There are some exceptions, which I won't get into, but for the most part, you can't prevent someone from earning a living in California. There are ways to address it and ways around it, but that's sort of the general position California's had for many years. Other states have a whole wide variety of ways they approach it. So if you take something down that was intended for one state from Google and you get a form, and then you start using it in other states because you're growing now and you're adding employees on in other states, and so you pulled down a form from Iowa and used it, it worked fine. So now you've got someone in Florida, and then you got someone in Colorado. Be very, very careful. And what I would suggest is don't do that. Go talk to your lawyer, because you need to look at every single state and understand what the differences are in their laws regarding non-compete and make sure that it's compliant. In some cases, actually entering into a non-compliant non-competition agreement can be a criminal offense. So just be forewarned. That's one area where there's a huge disparity in how states treat that. Another reason to get good advice. Okay, let me try to skip through the rest of this. So we talked about good corporate hygiene, preparing for your first deal, just touching a quick minute or two, being super organized. Try to understand what the investors are going to ask. If you're going out to raise money from investors, your first round, try to understand what sort of things are going to be important to them. I'm sure a lot of you will already have this understanding to a certain extent because you've gone and talked to a bunch. You probably pitched to a bunch of investors. You've got some feedback. So that's one piece of it. The other piece of it is understand it at a more granular level. So, okay, I've got all that stuff. I pitched, I did really well. I hit all the metrics that they're looking for. But what other questions are they going to ask me as we start to get into this deal? What are especially when it comes to really doing a deep dive on the company, the diligence piece, if you will. And there, really to do a good job and be as prepared as you can, organize your documents, set up the data room, have everything ready before you even talk to an investor or before you've even gotten a term sheet out. It sounds a little weird. It sounds a little out of step, but I can tell you that if you do it that way and you're super organized, it'll make things flow a lot quicker, a lot more efficient, a lot more effective. It'll allow you to work with your lawyers a lot more effectively and efficiently, which means you'll probably save a lot on the legal fees. I see a lot of legal fees get a lot higher than they otherwise might or should be. It's because there's a lot of disorganization, a lot of cleanup that needed to be done. The founder didn't do it, and now they've got a deal and they're under the gun. They want to close in 20 days, 30 days. And they push all that over to the lawyer saying, hey, I'm too busy. I need to keep running the company. We need to clean this up. So of course we can clean up a lot of that stuff, but it costs a lot more money to have us do it. And then using your advisors efficiently. Okay, so let me see. I think, yeah, I think some of the biggest thing I can suggest is just do your homework. Make sure you're really ready. Ask questions, talk to people, talk to your lawyer, talk to your other advisors. Make sure you're totally organized and ready to go, and that you're putting into place habits that will help you stay organized. I think that's also a really critical component. Okay, sorry, let me go back. I'm going to leave this screen up. If you have questions or comments and we didn't get enough time today, then reach out to me. My email's there, so don't hesitate to ask. Okay, let me go to see what questions we have. Second here. I think maybe people put questions in the chat. If you have any questions, feel free. Okay, here we go. All right. There's one question about, do I have a template of the agreement? I'm not sure what agreement you're talking about. If you're talking about the confidential information invention assignment, yeah, we do have templates. We do have forms that we prepare. What I'll tell you though is, always be very wary of using a form unless it's been, recommended by your attorney, or that someone, with a legal background has gone through it and really reviewed it. So forms are great, but they're a form. So I would think of them as sort of an initial draft. You really need to tailor it for your particular purpose. Certainly seen a few war stories where people just, as I mentioned earlier, used a form. It wasn't the right form, didn't have the right provisions, and then something came up and they realized they weren't as covered as they should have been. Yes, the slide deck will be shared, so the recording will be shared as well. And so you'll have a chance to view it if you didn't get a chance to view the full presentation or the slides. You'll have a chance to view that after this presentation. I don't think there were any other questions. So let me see. Actually, wait a minute. There is one. Okay. So let's see. I'm an angel investor in emerging tech and happy to advise startups. Okay, so that was someone indicating that they do investments. Yes, I don't see any other questions. So I know I rushed through a lot of stuff. We had an hour. We've got about 10 minutes left, so I'm happy to kind of go through anything else or go back to a few points if there are some points or issues that people want to get a little bit more information about. Just put it in the chat or the Q&A. Let me see. Yeah, I'm not seeing any additional questions. Let me check the Q&A really quick. While I'm looking at that, I'll mention, since we have a few minutes, I was on a panel presentation yesterday talking about legal tech, and there was the company that hosted it provides some legal tech solutions, document generation, and some other things. And so we had a great discussion with a couple other panelists, and the whole concept of, should I use legal tech? Is legal tech something I can use without a lawyer? So how should I approach that? And so I think everyone has slightly different approaches or philosophies. But I think for me anyway, I really want to embrace whatever technology is coming out to help in the legal area, because the more I know about what's out there, the more I can make sure I talk to clients about, and if it's something they can use, then they should use it. Again, the caveat being, use it appropriately, make sure that you're getting good advice. If you're just using a legal tech solution without understanding it fully, without getting good legal guidance, that can create all sorts of issues. Okay, so we got one question. Any special considerations to be made regarding IP and fintech? That's an interesting question. Well, I think, IP in fintech and some other sort of technology-focused companies is highly focused on, code and what's being implemented to allow the fintech to offer the services that they're offering and the products they're offering. So, one thing that's interesting and that I found out about a while ago is there's a little bit of a misunderstanding out in the IP world amongst founders, executives, entrepreneurs. I think someone somewhere many years ago had said, well, you can't get a patent on software. And that's absolutely not true. You can. I think there was a case that came out a number of years ago, and there was some issue about, that particular case with the ruling, and the ruling was basically misstated by people that didn't understand it that well, and then generalized to say you can't get a patent on software. So what I would say is if there is something that you can protect relating to the fintech company's technology, even if it's a code software program, don't automatically think that you can't get that protected. So go talk to an IP attorney, preferably one that has a background in that area, and let them guide you on, does this make sense? Can we get some sort of protection? Can we file a patent on this? So oftentimes I see that being discussed and addressed a lot. Okay. Oh, I'm getting a lot of questions here. Okay, so let's see here. Looks like they're coming through in a different format. Okay. All right, so let me go through some of these questions. Okay, so dangers of relying on ChatGPT. Yes, I would say be cautious. We talked about that yesterday too. So ChatGPT, I mean, it's amazing. It's incredible technology. It has a long way to go. What I oftentimes will tell people is if you want to try it out and get an idea about something. So, draft me write a non-confidentiality agreement or prepare a non-compete provision or something like that. It's good to see what it'll come up with. And it may be a good initial draft, initial starting point, but I can tell you it still makes a lot of mistakes. And so I would not use that exclusively. You may look at it and you may use it more for edification, so to learn about stuff. For example, if you're doing your first round, you might say, ChatGPT, write me a 500-word, 1,000-word memo regarding the process of raising financing by selling stock or something like that, and fine-tune your search. I think you'll get some good results you can read through, but you got to make sure you verify. So, you can use it, but I would not use it to rely on entirely. Okay. Okay, question. What is the name of the document you'll need if you need to let someone go because they can't execute their agreed upon responsibilities? Good question. So it depends on what their role is in the company. So if they're an employee and you've hired them, so for example, in the US and especially in California, a lot of times people are hired on an at-will basis, meaning there's no employment agreement for a fixed term. It's at will. So it's whenever the company wants to terminate that person, they can. Or if the person wants to leave at any point, they can. So usually we suggest doing an offer letter, not an employment agreement, unless it's a very high level, very senior executive, and the only way you can have them join the company is to give them an actual agreement. That's an area, I mean, certainly you can talk to me about it, but I usually work with our employment colleagues because employment agreements and agreements that are all related to employment are very, very specific, very state specific, and the laws are complex and many. So you really need to have a good employment lawyer manage that piece. So, I mean, Foley's a full service law firm. So when we get questions like that, if I'm fielding the question, I'll oftentimes pull one of my employment colleagues in. So it might be an offer letter, it might be a consulting agreement, which is another one, or it might be the restricted stock purchase agreement if a founder or if an employee or consultant's coming aboard. they're getting stock. If they're getting restricted stock, then there'll be an agreement, typically called a restricted stock purchase agreement. That'll have provisions in it so that if they leave whatever the services they're providing, if they're an employee or consultant, then the company has to buy back the stock that hasn't vested at the same price they purchased it. That's typically the way it goes, and there's vesting as well. Okay. What are the pros and cons of types of fundraising? How to find angels, crowdsourcing? Boy, that's a great question, but it might require another few hours. There are a lot of different ways you can raise funding, and I don't have enough time to go into all of them. But very quickly, there are SAFEs, which is a simple agreement for future equity, developed by Y Combinator many years ago. Convertible notes. And then, the third option is you actually sell stock. So what we typically call a priced equity round, where you're actually pricing the stock and you're selling the stock. You're not giving someone a SAFE, or you're not giving someone a convertible note. You're actually giving them stock. So those are sort of three ways. You can take out loans. There's venture loans, venture debt loans. There's grants. There's all sorts of other fundraising opportunities, but those three are typically the most common that we see. Okay, so I got a couple more minutes. Let me see if I can. How to find angels, crowdsourcing. I mean, it's very much network based. There are some angel networks around there, so you can look at those and see if there's people you can meet or go to some of the events. Ask folks that have been around the block and had some companies. Another question is, when working with the university to do work for the company I'm paying, how is IP ownership dealt with? That's a great question, and that also is one that will require more time. But essentially, if you're doing any work with a university, academic institution, nonprofit, et cetera, you need to be very careful, because oftentimes if you're employed by the university, or if you're working with someone who's employed by the university and they're developing technology that may be funded by the university or by a grant provided to the university, then there's going to be all sorts of issues you need to be careful about. And typically there'll be an agency or a department within the university that manages how that is done. So how you negotiate rights to IP or rights to technology that's being developed that you want to spin off into a for-profit, a private company. Okay. Things to be aware of in converting an LLC to a Delaware C corporation. Good question. A little bit more complicated in the time we have, but very quickly, I'll tell you that if your journey involves raising financing from outside parties, i.e. investors, then you typically are going to want to have your entity be a Delaware C corporation, because that's the entity that most investors prefer. I've done deals where we've had a California LLC raising financing, Delaware LLC raising financing, but I'd say probably 90+% of investors prefer to have a Delaware C corporation. So they can be converted. So if you create an LLC, you can convert it to a Delaware Corp. It's a little bit of an involved process depending on what state you've created the LLC in, and there's some tax consequences you need to be aware of too. So that's where you need some good legal advice. Okay, I don't think I'm going to be able to get to all of them. I think we're at 10 o'clock. We'll go on for a few more minutes here. Let's see. How to deal in trading over foreign country suppliers. Actually, let me back. Yeah, let me talk about that one. So if you're trading, let me see if I quite understand how to deal in trading over. So if you're sourcing materials from suppliers that are outside the U.S., if that is the question you're asking, then you just need to be careful that there are tariffs, there are laws on the books here in the U.S. of what can be imported depending on what country it's coming from. Are there any sort of prohibitions? There are import-export controls. So you just need to make sure that you touch base with typically a lawyer that focuses in that area, that understands the different import-export regulations, to make sure that you don't bring something into the U.S. that is controlled or that you need a permit or a license for. And it's not only by product, but it's also by country. So and also by individual. So that's where it gets a little bit complicated, but you need to talk to someone who really understands that, so you don't run afoul of those laws. Okay, so with regards to legal tech, can you use ChatGPT to make legal documents? U.S. Copyright Office doesn't recognize non-human copyright, and legal documents are written text. Yes, you can use ChatGPT to create legal documents, but I would caution you not to. again, ChatGPT, it's been in the works for a long time, but it was released to consumers, the public, relatively recently, and it's still in its infancy. It is not particularly accurate. So you need to be really, really careful when you are using ChatGPT. As I said, use it as a draft and then go get good legal advice to make sure that what it came up with is either on base or off base, or use it for educational purposes to learn about things. But I would not draft documents using ChatGPT. When is it proper to split 50-50 when you are a non-tech founder with an idea premium and you are handling the first year's finances? So I think that's the example I kind of gave was, when you're allocating equity amongst founders, you really need to sit down and figure out who's bringing what to the table. So in this example, you have the idea and you're also going to be taking care of the first year's finances. So you're doing, quite a bit. In my view, if I was representing that individual, I'd probably say you should ask for more than 50-50. If you're covering all the expenses initially and you've got the idea for the company, then essentially it's really your company, and you're bringing someone else in, maybe that's got the technical ability to take it to the next step. So maybe it's a split that favors more your participation, money, and idea than just bringing in someone that work on the tech. It's hard to give you percentages. It's a more involved conversation, but I think it would definitely be an area that'd be reasonable to ask for more than just 50-50. Okay, would you please elaborate as to why you prefer sending prospective employees an offer letter rather than an employment agreement? Yes. So in the US, and especially California, if you give someone an employment agreement for a fixed term, so let's say you give someone an employment agreement that says, you're going to come work for me in this role, and here's an employment agreement for a year. That means essentially you've committed to paying that person for a year. I mean, again, you can put provisions in the agreement, but that's the concern, that's the worry. And so if you're not careful, you end up signing an employment agreement with someone, giving them a fixed period of time that you're going to be employing them. So if something happens and they don't work out, you want to let them go. You still got to cover the rest of that period of that term, unless you've got an out in the agreement. So maybe it says, for example, if we fire you for cause, then the employment agreement terminates. So there are ways to draft for that. But what I've seen happen is a lot of times people just say, yeah, this is great. You're going to work for a year. I need a year because I'm moving from another state. So I need a commitment. Company signs an agreement for a whole year. It's $200,000 a year. And then suddenly 3 months into it, doesn't work out, and they don't have the right language in the agreement. Now they're stuck. So it can be a really big ticket item to fix. The better option is to do at-will employment. You may not be able to get it for very, very senior people, but by far and large in the US, we see the at-will being the preferred way to go. Okay, and let me, I'm just going to check really quickly. I don't know, Matt, if you're still on. I just want to do a time check to see. I know we were going to reserve some time at the very end. So I think we go to 10:30. Okay, good. So we go to 10:30. So we've got plenty of time. Okay. Yes, the recording will. Another person asking for the recording. The link will be made available, so you'll have a chance to listen to it. Slides will be available as well. And let me see if I've missed a few questions. Okay. So how do you suggest approaching a situation when the founder has been working on tech for 5 years and is adding a co-founder who's happy with 10%? Is it unusual for a split to be 70% for the founder, 10% for co-founder, and 20% for future employees? Good question. And the percentages are, so I'll say this, when you're looking at percentages and divvying up the pie, if you will, ultimately you need to recognize that whatever you divvy up now is likely not going to be the same ownership pieces that will come much later on. So as you go and raise more money and issue more shares, or issue shares to employees, consultants, et cetera, then everyone's going to get diluted, as I mentioned in the earlier part of the discussion. So, you need to keep that in mind. So if you have 100% when you first start, and then you got a co-founder that is coming in for 30%, or let's say 10%, then you've got 20% you want to set aside for future employees. That could be a workable solution, but just recognizing then that's the snapshot of the piece of pie now. So in 6 months or whenever the point in time is when you're going to go raise money and you're going to get an investor to come in and buy 20% of the company for, let's say, 3 or 4 or 5 mil, whatever the amount is. Now you've got to account for the 20% diluting everyone, including your 70%, the 20% from the other, or the 10% from the co-founder, and the 20% that's going to go to the other employees. And because you have the 70%, you have a much larger piece of the company. The 20% the investor is going to be purchasing is going to have a much more dilutive effect on you. The impact will be much greater on you because you have so much more than it will be on the 20% employees pool or the 10% that your co-founder holds. So you just need to be thinking about that. So going back to the cap table, and if you're using a cap table management program, Carta's one example. They just built in a new feature, I think a few weeks ago, they released it, where you can actually create a pro forma that will show you what will happen to the ownership and the shares, as you go and add more people in. So as you take on investors, they come in and buy 20% of the company. What's the dilutive effect that is going to happen to me being the founder? What is that going to look like? I mean, oftentimes us as lawyers will prepare the pro forma or prepare it in conjunction with the company. But the nice thing about this feature that Carta released is they can do it like that. So the fact that you've got all your data up in Carta, you can probably press a few clicks of the button and it'll spit out a pro forma fairly easily. Okay, so we've got a few more messages. Let's see. I think I've got messages showing up in a couple of different places. Okay, so getting early advisors off the cap table when converting to Delaware C, buying them out, etc. That's a really good question. That does come up from time to time, and I've seen that come up especially when the company's being set up and there wasn't good care and consideration given to how to allocate equity amongst co-founders or very, very early employees. And so the missteps I've seen that have taken place are founder sets up company, has a buddy or a friend or someone gets introduced to him, he's all excited or she's excited, thinking it's going to be a great addition, and they just give up a huge amount. They give up 20-30% of the company, thinking this is going to be this person is going to be my co-founder and they're going to help me become successful and the company's going to do great. And then it turns out not to be the case. After 6 months, the co-founder decides, you know what, I just don't have time. I've got to go. I got an opportunity to go work elsewhere, et cetera. So see you later. If you don't have the right documentation in place, they leave with 20 or 30%. Now you've got somebody on the cap table that we oftentimes refer to as dead equity because they're essentially dead from the company. They're not contributing to the success growth of the company anymore. So they're sitting on the cap table, taking up 20% or 30%, whatever amount they have, but they're not contributing to the company's success. Big problem. Investors do not like that because that's a huge chunk to be held by someone who's not doing anything to move the startup further along in the journey to be successful. And so oftentimes what will happen is either the founders will try to buy them out, or in some cases, investors will come in and say, you got to clean this up. You need to buy the person out. In some cases, I've seen, where the technology is really good and the investors really want to get in, they will sit down with the founders and work out a way to try to buy that person out. But, it can be very expensive. Okay, so another question that came in was, with regards to share percentages, may I ask what were the best and worst distributions of shares you've ever seen in your experience? Great question. I think the worst example I ever saw was the one I gave early on, where the person that created this great technology had given his friend 50% of the company up front without any payment, without anything other than, yeah, hey, I'll manufacture the products for you. And then that ended up being a total disaster. That was probably the most extreme example of a bad distribution. So what he should have done is either given him a much smaller percentage, and if the relationship worked and he was able to deliver, or she was able to deliver, give them more. Or if they were going to give them such a huge amount, then you need to make sure you've got an attorney that drafts the agreement in a really careful way so that if the person doesn't work out, they leave, they can't deliver, then all those shares come back to the company, and that agreement is done really, really tightly. Okay. Another question for a new startup: how much should they budget to have a lawyer review all their documents to make sure everything is in order? It's a good question. If it's a new startup and there aren't a lot of documents, I can't give you a specific amount. I would say, reach out to me separately via email, and I'd be happy to talk with you and give you a suggestion. But it shouldn't be a big spend. So, for example, if you've gone to one of the many legal tech solutions to help form your company, so there's a couple that come to mind. Clerky is one, LegalZoom, Atlas. There's a whole bunch of them, but Clerky, I've seen a number of their documents, and I think overall it does a pretty good job. But what happens is that if you're not really careful and you're not really thorough in reading the directions and understanding everything that needs to be done, oftentimes steps will be missed or forgotten about or not followed through on. And so what happens is you get maybe 80%, 90% of the way there, but some of it's left undone. And those items that are left undone need to be taken care of and completed. So the point of this is, coming back to your question, is, I would estimate a few hours to go through all the documents, make sure everything's kind of ticked and tied and understood as to where there might be some deficiencies. And then to have the attorney come back with a proposal. Okay, here are all the deficiencies we noted. Here is the solution, here's the recommended course of action to fix it. And here's what we anticipate the cost would be to get it all fixed. That can be a good way to go. Oftentimes, startups don't have the budget, don't have the money to hire an attorney initially. What I will tell you is a lot of firms will work with you to come up with a payment plan or some sort of alternative fee arrangement that makes sense. It's a case-by-case basis, so I wouldn't initially think, well, I'm never going to be able to get an attorney because they're going to be too expensive. I wouldn't think about it that way. I would find the right attorney you want to work with, the right firm you want to be with, and then talk to that person and say, okay, how can we work together? What can we work out? And see what opportunities or options there may be. But having said that, if that's not an option, and using a legal tech solution like Clerky or some other provider, then make sure that you do go to an attorney and get it reviewed and cleaned up. So that would be a good suggestion to do that. Okay, so in your experience, were there any commonalities between startup companies that failed? What were the biggest fights that you've seen between investors and founders? So the first question is, yes, they say that sort of the three pillars of a startup that are critical is you have to have good technology. I mean, if you just don't have something that solves some problem, there isn't a good solution for it, then it doesn't matter how good your team is or how much capital you have. It's probably not going to ultimately be a really successful company. So good technology. You need a good team. If you don't have a good team and you've got great technology and you've got cash, then the company may be mismanaged. It may not be growing appropriately, may not have the right ability and leadership to get it to the next stage, so it may fall apart. The third pillar is making sure you've got capital, because oftentimes a lot of these startups need a lot of capital. It's intensive. If you're building a product, you're developing technology, you've got to hire the right people. They don't come cheap, and it can take a lot of money. So those are the three pillars I've seen. If you're missing one of those pillars or two of those pillars, I would say where I've seen a lot of failures is they just don't have those three pieces, those three critical pieces. Don't have good technology, don't have a good team, don't have capital. And you may be able to get by without capital initially if you're doing it yourself. And let's say you and your co-founders, there's three of you, you've got the technology, you've got the technical skills to be able to build the technology internally yourselves without spending a lot of money. Great. Then you may be able to build a good technology. You understand it because you've got the technical know-how. So maybe you've got enough of a good team initially to go and attract capital. And then once you get the capital in, make sure you then build out your team. So you not only have the technical expertise, but then you've got the other areas that are important too. The ability to understand finances and manage the company, the leadership skills. If it's someone that it's going to be a very sales intensive business, maybe it's someone who's got a background in sales. So building out that team is going to be really critical. Those are the three pillars I see where if you're missing them, I see a lot of companies fail that don't have that. Or the biggest fights that I've seen between investors and founders. Well, I think I like that question because, initially when companies are courting investors, there aren't any fights. It's just more negotiations. So, the negotiations typically are around what the investors need to have in order to give the green light to do the investment, and they have their own matrix for things that they're looking for. But essentially, if you were to distill it down into the essential elements, it's how can I get a return on my investment? So if I'm a VC company and I'm putting in $10 million, how am I going to get that back? Not only the 10 million, but I need to get it back with a certain multiple of that to make that investment worthwhile. Because keep in mind, the majority of startups fail. And I'm sorry to share this, tragic news, but maybe 1 out of 10, used to be 1 out of 10, maybe now 1 or 2 out of 15. But it's a very low number of startups that really become successful, and successful to the point where they will make up all of the other failures or all of the other startups that don't succeed, the investments that VCs put into them. Because if you're a VC and you're putting in money into different companies and you invest in 10 different companies, already that the likelihood is that probably 8, 9 of those companies are not going to be successful. But that one, or maybe it's out of 15, but that one that is, or the 2 that are going to hit it out of the ballpark and generate a multiple on that initial investment, which, maybe 5, 10, 15, 20, 30 times what the investment was or more. That makes up for all of the investments where the company wasn't successful. So you have to have that in mind. So where I see a lot of negotiation is how to protect that investment, how to make sure they get the largest return on investment. It's having certain rights, having certain controls. Those are areas where I think are the most hotly negotiated parts of the discussion, the dance, if you will, between the investor and the company. Okay, we've got a few more minutes too. Let's see. For a new startup, how much should okay. One firm I went to said the work would be around 8K, but they needed a retainer of 30K in advance. Oh, that's yeah, I would say go to a different law firm. If they're just reviewing documents that you've already prepared, unless there's something that I don't know about, and I don't want to second guess another attorney, really need to know the facts and circumstances. But I typically would say if it's a plain vanilla general startup package, you have, minimal set of documents, you need someone to review and make sure everything's done properly. Example was, you come to me with your set of clerky documents you used. It shouldn't take more than a few hours to review that and come back with a sort of a bullet point list of are there any problems. Asking for a $30,000 retainer, I'm not sure what the project is, but that's a pretty significant project. So I think you need to understand why they're asking for so high of a retainer, especially for a startup. Question from somebody about, can you get an attorney to work for shares? Yes, there are attorneys that will work for equity, but it's typically frowned upon because there are all sorts of rules in place about making sure there isn't a conflict of interest between the lawyer's representation of the company and the lawyer's interest in the company if they're getting an equity piece. So yes, it can be done as long as it's done properly and there are appropriate disclosures and appropriately, appropriate information provided to the company that, it's a small enough amount of shares that are being given to the law firm or the attorney that it's considered de minimis, so unlikely to create a conflict of interest because, no matter what happens, the amount's relatively small or so small that it's not going to have a huge impact on that attorney's ability to be unbiased and objective. So I would just, I would caution you, it's typically frowned upon, can be done, but needs to be done very carefully. Let's see. So it seems to be pretty difficult to manage a timeline when it comes to secure IP, build a prototype, and getting investors to sign up. Do you have any experience in this respect? The timeline is, yes, it's challenging, right? Because you need to develop the technology. If it's the kind of technology that can be protected, I certainly encourage you to talk to your IP attorneys, and if it makes sense to file a patent or a trade, whatever the protective, however you can register it to protect it, that should be a discussion you have with your IP attorney. And that can be expensive. There's creative ways, strategic ways to approach that. And that doesn't necessarily have to take a long time. So if you go to a IP attorney and you've got an idea for a patent or possible patent for technology, they can file a provisional that might be very quick, or they file the full patent and it may take a while, but it shouldn't be a huge timeline. So, but again, I would talk to the IP attorney, understand what the timeline is, how long it's going to take you to build a prototype. That's unknown. I mean, it depends on the specific circumstances, and getting investors to sign up. The investor piece is going to come at whatever point in time that you're talking to investors who will be interested in the company. Some investors will invest in very early stage startups. So before you really have anything, you may have an idea, you may have proof of concept, you may have a prototype, or may not have a prototype, but it's intriguing enough, attractive enough that the VCs or the investors understand the space, understand that yes, this is going to be a killer product, killer technology, and they want to get in early because they realize it's going to do really well. Then they may be interested in investing before there's any revenue, before there's a prototype. They're all different. So you really just need to make sure you understand what the investor is looking for and what their requirements are. But I think you can manage that timeline. It just means you need to be really proactive and you need to be diligent about making sure you're following through with the various steps. Okay, so let me see if there was any other questions. I think I answered. Yeah, I think those were the questions that I saw. So let me see if there's any other questions that people had. Thank you by the way, for such wonderful questions. This was great. I think we are good. I don't see any other questions. If I missed any, let me know, or put it in the chat again if I went a little bit too fast. But I think I covered most of the questions that I saw here. So again, if you joined late and didn't hear, the link to the recording will be made available, and the slides will be available as well. You'll see that when you get the link. Okay, so I think I don't see any additional questions. We've got a few more minutes remaining. So I think if I could summarize and take everything we've talked about and all of your wonderful questions, I would say doing your homework and spending the time to really understand what the issues are that are important in any given situation regarding your company, regarding your startup. So whether it's allocating equity, whether it's deciding on doing a joint venture, whether it's deciding on going and filing a patent for your IP, or what employees to hire, all of those scenarios, the kind of documents you need to create for the agreement for the company, is just make sure you do your diligence. And the other piece of that, which goes hand in hand, is you do need to get some good guidance from an attorney, because some of this stuff is very complicated, and it's stuff that, as I mentioned in the number of the war stories, you can make a misstep and then end up with a horrible situation. Sometimes you can clean it up and get out of it. Sometimes it's really expensive, and other times you just can't. But doing your homework and understanding the issue as much as you can, and then going and talking to your attorney will help tremendously, because it'll also, you'll be able to understand the attorney much better. You'll be understanding the issues because you've already got a little bit of a foundation in them. It also helps save time, because you might be able to sort of bypass some of the initial discussions because you've already read up on it, you already understand it, so you can get down to, okay, here are the issues I have, here are the questions, let's talk about that, rather than spending time going over generalities or having the attorney provide you with sort of the foundational basis of the issue. If you already understand it, then you can be that much more succinct and that much more effective in your communications with your attorney. It saves a tremendous amount of time, and I think what happens a lot of times is, especially on deals and financing deals, you'll see a lot of time spent to clean things up, to understand the missteps, to figure out how to get around them or resolve them. And that consumes a lot of time. And believe me, it adds up and adds a tremendous amount of expense to the overall transaction. And if you can shorten that piece, you not only will help close your deal a lot quicker, but you'll also end up saving a tremendous amount of fees. I've seen, and I've been involved in a lot of deals where those sorts of things weren't done. There was a lot of cleanup, a lot of issues that needed to be corrected. And so we ended up cleaning all that stuff up and correcting it, but it took a lot of time. It caused delays in the transaction, but it also ended up adding to the overall expenses. So that would be an area, if there's anything to take away from this, and there's a lot of resources out there. You can read a bunch of articles, try out ChatGPT and say, hey, tell me about, what are the 5 big issues to be aware of with regards to granting options? And I'd be curious. I'm going to run that search myself to see what it comes up with. So try that out. Do some research, read some articles. There's a lot of webinars on the web as well. You can go. YouTube has a bunch of stuff. Take them all with a grain of salt, because you got to keep in mind these are all perspectives that are being given to you. And until you really vet the perspective and know that the information you're getting is coming from a really credible, reliable, experienced source, you need to make sure you sort of sift through some of the stuff that you don't know if you can rely on, and get to those resources that you can rely on. I'll give you one example, and then we'll close out the day. So if you find a bunch of articles and they're talking about really complicated stuff about option grants and issues and taxes, but it's not written by an attorney, it's not written by an accounting or tax professional, then I would be a little suspect. Not that it's wrong, but then you should go and rely and find something that supports that is based upon someone with a lot of credibility and knowledge. So you find something, maybe it's a reporter that wrote a really good article on how to grant options, what are some of the issues. Then you go and double check that by pulling some articles down by some attorneys at law firms that are very reputable. Check that with your tax advisors or accounting firms. And if that's all consistent, then okay, then that's good information that you can, take in and say, all right, that was a good article. But otherwise, you got to be a little bit careful on what's out there. There's a lot of misinformation out there on the web, so you just have to sift through it carefully. Okay, I think we're sort of at the end of the hour. I want to thank you all. I know it was an hour and a half, so it was a long time to sign in and participate, but really enjoyed speaking to you. Really enjoyed passing on some of the things that I've seen over the years. Hopefully, it was helpful. Hopefully, it gave you some ideas of where those mines are, where those pitfalls are that you'll be avoiding when you are on your journey. Feel free to reach out to me if you have questions or want to get in touch. And I do thank you for taking the time to listen in today. So really appreciate the opportunity to present to you today. Thank you.